Good morning, everyone, and welcome to We'll Work for Food. Today is May 27th, 2021, and it's a pleasure to see you all. We're here today for a presentation on ADA accessibility cases and are privileged to have Ara Sahelian with us. But before we get to the presentation, first, Jeff, can you tell us how much has been raised so far?
Thank you, Jean. You know, as part of the We'll Work for Food project, we don't charge for these great webinars. Rather, we ask people to contribute to a food bank, either one designated by our speakers or any food bank of your choice. Since Natalie Armstrong-Motin founded the We'll Work for Food project in the spring of 2020, and we began these programs a little over a year ago, our generous audiences have contributed over $112,630 to food banks worldwide. So to our generous audiences, thank you so much.
That is fantastic. And thank you and kudos to Natalie and Jeff getting this started, keeping it going and keeping it interesting, and to everyone who has ever spoken on We'll Work for Food. It's just fantastic. So I'd like to introduce to you today Ara Sahelian, and he'll be talking about the anatomy of an ADA accessibility lawsuit. There are different parts to the American Disabilities Act, and so the focus today will be accessibility. Mr. Sahelian has been practicing law since 1993. His office is in Orange County, California, and the thrust of his practice is primarily civil litigation in both federal and state courts. Currently, 3/4 of his practice consists of defending small business owners in ADA lawsuits, and he has defended more than 200 of those. Prior to practicing law, he was an aerospace engineer and does have his degree in engineering. He attended law school at night while working as an engineer. His comments today are meant to inform. The ADA, of course, dates back to 1990, and most of us can't even remember anymore what it was like to have sidewalks without the curb cut out in them so that a wheelchair or a baby stroller or anything could go down them and easily cross the street. So I'm sure we will have a lot of insight from Ara. His charity today, or his food bank, is Action Against Hunger, actionagainsthunger.org, and Natalie will put that information in the chat. They have a staff of nearly 8,500 people serving more than 17 million people in 46 countries last year. It's truly a worldwide global food bank, an organization that does much more than feed, but it feeds people in many ways. So Ara, the floor is yours.
Thank you, Jean. Just if you don't mind helping me out a bit, I want to make sure I know how to present here. So how do I simply press share screen and we're ready to go?
Hopefully, yes. That's good to start.
Okay, you'll tell me if the presentation doesn't appear. Okay.
Will do.
Let's see. There we go. I think we can make this work now.
Right. You've got your side things. Yes, you're perfect.
We're good to go. All right. Well, good morning, everyone. So we're going to jump into the world of ADA this morning. I believe we have some in the audience who are not from the United States. So bear with me. I will try to give this a little bit of an international twist. We'll start off with this picture. This is a picture I took in Barcelona, a wonderful city for anyone who is in a wheelchair like I am. And I'll talk a little bit more about this this particular picture later in the program. So let's start along. I've got a number of slides that I want to get through and try to cover as much as we can. So what we're going to do is go through some of the issues that come up with the Americans with Disabilities Act currently. First is online shopping for those who are visually impaired. Then we'll cover the architectural barriers for those of us who are like me in a wheelchair. We'll delve into a few of the specifics of the ADA and the California's Unruh Act. We'll talk about the proliferation of ADA lawsuits in California. And finally, if some of you are mediators, we'll discuss what it takes to settle some of these cases and the trial strategies employed by both plaintiffs and defendants counsel. A little bit about me. That's me, as you can see, in all my handsomeness. I've handled, defended in excess of 200 ADA cases. I am in a wheelchair. I've had childhood paralysis, but as you can tell, it doesn't stand in the way of having me do whatever I want to do. I take my wheelchair in the back of my Volvo station wagon, and I make sure that my clients help me out when we get to court. So my running joke is that's what clients are for, or to help their attorney, right? So what is disability? I mean, disability is a difficult concept to define. Here you have this man who managed to get himself up 250 meters in a wheelchair. Is he disabled? It's a good question, isn't it? Then we have one of the most consequential figures of the 20th century, our President Roosevelt, who did so much confined to a wheelchair. Was he really disabled? It's a good question. So my life on a daily basis is to defend small business owners. That's what I like to do. Not necessarily because I am against the ADA, quite to the contrary. I am for the ADA, but what I don't like is when the ADA is being abused. And some of the victims are small business owners. And my job is to make sure that if a business has been sued and the lawsuit has merit to it, that we take care of the issue and that we settle the case. On the other hand, if the lawsuit is meritless and if the claims made have no factual basis, then I will defend that case and I'll take it to trial if I have to. I will essentially get into a little bit more of the specifics of the ADA as I show you photographs, which you know, as far as concept, the ADA concept goes, it's a lot easier to get across when I show you photographs as opposed to speaking about it abstractly. These are the links to the Americans with Disabilities Accessibility Guidelines. They're complex. There's about 270 some pages of code. There's photographs that help, but it's complex and it takes time to figure out. But anyone is free, obviously, to take a look and see if it will help them. Now, this is a chart that I created a couple of years ago. My office did an inspection of a 40 restaurant chain in Southern California. And what I did is I had 3 people from my staff go to each restaurant and we surveyed. And as you can see, each one of the columns is a parameter. Parking lot, dining area, men's room, and the red dots are violations. We found all in all close to 800 violations, which we managed to correct in about 4 months. They were getting sued once every couple of weeks, and we managed to bring that to a stop within weeks. The Unruh Civil Rights Act was enacted a long time ago, and the ADA was incorporated into the Unruh Civil Rights Act in California. And the purpose of the act is to prevent discrimination. Originally, the concept was, originally the concept did not include the Americans with Disabilities Act, but it was incorporated into it back in the early 2000s. And it essentially says that if you're a business owner and if your property does not comply with the Americans with Disabilities Act, then essentially the plaintiff, the disabled person who's been discriminated, is going to be entitled to $4,000 per incident. It is an extremely costly mistake for a business to make not to have full compliance with the ADA. At $4,000 per incident times 3 incidents total, that's at $12,000. That is an expense, a cost that most small businesses cannot afford. So this is where I come in and help. So considering that it can be very profitable to file an ADA lawsuit, as you can see from this chart, this is a survey that my office did back in 2019. These cases have proliferated throughout the courts. As far as the federal courts in California are concerned, close to 20% of their workload is consists of ADA lawsuits. The law firms that that file the most here are the Center for Disability Access, also known as Potter Handy, the Manning law firm here is shown as roughly 4%, but I believe their share is grown much larger since, and some of the other players here that are prominent. They file these cases essentially by the hundreds every year. As I indicated earlier in this presentation, one of my jobs is to make sure that businesses are protected from claims that have no merit to them. And I will take credit for putting this man, his name is Jose Velez, out of business in California and in Oregon. I was able to defend each one of the cases that he brought and have them dismissed, over 8 of them. And I just had the last one in San Diego dismissed without paying a cent. He claims he is disabled, and he is not. He claims he has morbid obesity, which prevents him from being able to get in and out of chairs easily, or that he requires special accommodations. And the fact is, we've got him on video, and he's more athletic than an Olympic runner. So we got him. This is a chart, if you will, that we found. I believe it was published by the Access Board, and it essentially it's sobering in that so much of the population is to some extent limited in the things that are important to us on a daily basis, whether it's mobility or visually or hearing wise or whatnot. So obviously we want to make sure that all of these persons have full and equal access to businesses and public accommodations, and that's what the ADA aims to do. So the first type of litigation that we see in the courts that's become more and more prevalent are the website readability cases. If you're visually impaired and you're unable to read a website, it's a problem. And typically what you'll find is a complaint that reads like this. You know, I am visually impaired and I tried to use your website. I tried to go to the menu. I tried to understand what the picture was on the screen, and you gave me no description. Those have been found to be legitimate claims. And what we do in our office is we have software that's called JAWS, which is the standard software for evaluating websites. And we don't use experts. We test it out ourselves, and it gives us a quick indication as to whether the claim is legitimate or not. And most of the time, if we find that the plaintiff's claim is legitimate, we ask our clients to get it fixed right away, and we then go to the judge and tell them it's fixed. That way, if we can get it fixed within 30 days, the Unruh damages are dramatically reduced. Now, my favorite subject, architectural barriers. These are the classic ADA issues that have come up over the decades. That became very prevalent after the Second World War, when veterans came back and they were confined to wheelchairs. They couldn't get upstairs. They couldn't go to restaurants. They couldn't join their friends, which essentially set the foundation for the enactment of the ADA. So let's go through what typically comes up in lawsuits in ADA cases. We'll start with accessible parking. What you'll find in the United States and probably in most of European countries is an accessible parking space that's mandated for all public accommodations. You'll find that on the left side of your screen, you have a van accessible parking space, which has to naturally be wider to allow a van to eject its ramp and allow a wheelchair user to come out into the access aisle, which is the striped area in the middle. If the cars were parked very close to each other, naturally, someone in a wheelchair would be unable to exit. So you need that extra space. So that striped space is called the access aisle. It is very, very important. In the United States, it has to be 8 feet wide, or the combination of the accessible parking space and the access aisle have to be 17 feet. Naturally, the person on the right who uses a walker or possibly crutches will not need the entire 8-foot width. He can probably get away with 5 feet. So there are access aisles that are 5 feet as well. But the first accessible parking space in every parking lot has to be van accessible with an 8-foot access aisle, which is a total of 17 feet. This is a picture of a historic town in Europe, and as you'll see later in the presentation, I've been to Europe many times, and you know, when you have old cities, you don't have the same luxury as you do here in the United States. So you do with whatever you have, and for most people, this is good enough. some parking is obviously better than no parking. This is a case that was just presented to our office. A typical grocery store in the middle of nowhere in one of LA's suburbs. And what it does, it has 2 accessible parking spaces, but neither of which is workable. And I'll explain why. By the way, one of the accessible parking spaces is all the way on the right, and the other one's all the way on the left, and neither works. So let's start with the one on the left. You've got obviously a reasonably wide space, but the access aisle on the right is on a slope. And when you have an access aisle on a slope and you're trying to get your wheelchair out, it doesn't work because your wheelchair has a tendency of sliding down. So that access aisle has to be flat to plus or minus 2 degrees to make it possible for someone to exit their car comfortably. As you can see, though, it does rise to the sidewalk. So in that respect, it works, albeit not that well. Now, the one on the right, great, it's flat. It has an access aisle, but there's no way to get up on the sidewalk. So I don't know what they were thinking, but naturally that needs a ramp to make it work. This is something I found on the internet, which I thought was funny because it's supposed to be a ramp, but there's no way to get a wheelchair on it because you've got a couple of steps. So let's talk about getting up on the sidewalk from parking. What you see in front of you is called a built-up curb ramp. Built-up curb ramps are acceptable unless they protrude all the way into the access aisle. And the reason for that is, conceptually, as I explained a moment ago, the access aisle has to be flat. Otherwise, when you pull your wheelchair out of the car, you don't want it sliding all over the place. You want it to be stationary so you're able to transfer from the car to the wheelchair. So long as the built-up curb ramp is confined to away from the access aisle, the operable parts of the access aisle, you're good to go. This particular issue has led to hundreds of lawsuits, dozens of which I've been involved in, and I'll show you another one that I was able to dismiss without paying any money. This one we settled because the sidewalk was on a slope as well, and we just asked the client to make all the corrections at once. This is ideally the way you want a transition from the parking to the sidewalk. It's got flared ends, and if the wheelchair user is not paying attention and is sliding downward, it essentially helps the wheelchair center and not fall off the sidewalk. So it's a good design, and it's being incorporated everywhere now. This is a lawsuit I was able to get dismissed because this particular built-up curb ramp is perfectly okay. It has the proper slope of no more than 8%, and it does not protrude into the access aisle, meaning it doesn't interfere with someone who's in a wheelchair trying to transfer into their wheelchair. It's a good design, and originally the plaintiff wanted something on the order of $5,000 in damages plus an injunction to force the property owner to get this fixed, which was going to cost $15,000. We were able to dismiss the case outright. Now, here what you have is what you would normally see in a city environment where you have a number of businesses along a sidewalk, and you've got to step up into the business. So what do you do there? You can't have a permanent ramp on the sidewalk. That will interfere with sidewalk traffic. So the law allows you to have a temporary ramp that you can pull out anytime you have a customer who's in a wheelchair, and this is essentially what it looks like. In this particular instance, this is a marijuana dispensary in West LA, and they have a security guard at all times ready to help out with the ramp. This is a situation that comes up in most grocery stores. The ADA requires that circulation aisles be at least 36 inches wide. And here we have just that. Each one of these tiles is roughly 12 inches per side. So you can see you've got ample room for a wheelchair to slide back and forth. So someone who's in a wheelchair, who wants to shop on their own, is able to do that here. This is a floor plan of one of our clients' grocery stores. As you can see, each one of the circulation aisles exceeds 36 inches in width. And where you transition from one circulation aisle to another, you have plenty of space to make that turn with your wheelchair, even if your wheelchair is rather large. So this floor plan works real well. This doesn't work. I'm sure I'm sure you've seen this. And if you have a grocery store that looks like this, you're going to be in big trouble, which means you've got to figure out a way of widening these circulation aisles. The next important thing with grocery stores and all retail establishments is the sales and service desk. Obviously, you want the person in a wheelchair to be able to slide up to the counter and to be able to use their credit card without having to stretch their arms all the way up. And you want somebody in a wheelchair to be able to see the screen of the credit card reader. By law, the counter can't be more than 36 inches high, and by law, there has to be enough space in front of the service counter for a wheelchair user to park. And this is the subject of innumerable lawsuits. This comes up almost weekly in our office. I thought this was entertaining. The photograph on the left was supposed to be an accessible service counter, but as you can see, is being used as a display for some very interesting liquor that I wouldn't mind having in my house here. And so we made sure that the accessible service counter was cleared and was being used for what it was meant to be used for. And as you can see on the right, the credit card reader is right there available for the use of someone in a wheelchair. Now, this is a service counter of a gasoline station, convenience store. And right now, this case is up on appeal. We have 2 appeals going cross appeals, essentially going against each other in the 9th Circuit. I defended this case and I prevailed. The plaintiff was not happy, so they appealed the judge's decision. At the same time, I asked for attorney's fees because I felt that the claim was meritless, and the judge denied attorney's fees, so I decided to take that up to the 9th Circuit Court of Appeals. Essentially, the plaintiff argued that this 2-tier service counter was unacceptable. And their contention is, well, you know, while the lower service counter is available to the person in a wheelchair, you invariably end up transacting over the higher counter. And my argument is it doesn't matter where you end up transacting. If you're someone in a wheelchair, you can ask to be to have the products brought and placed for you on the lower service counter. So that's not an issue. And furthermore, the Americans with Disabilities Act accessibility guidelines allows that lower service counter to be present. So, you know, what's the problem? If the code says you can have that, then you shouldn't, you know, as a business owner, you shouldn't have a problem with it. And then the other argument that plaintiff made was, well, you've got an accessible service counter, but you're displaying products on it. Okay, fair enough, but there's ample space to place your credit card or cash or whatnot. So those products being advertised on the accessible counter aren't really getting in the way. And there's case law on this, several in the Ninth Circuit, and the Ninth Circuit has essentially held that so long as the products advertised are not excessively interfering with the use of the accessible counter, then it's not a problem. So we'll see where this case goes. Restaurants, my favorite clients. Every restaurant has to have an accessible table in each dining area. 5% of the tables in each dining area have to allow a wheelchair to slide under a dining table. So if a restaurant has indoor dining and 2 patios, each of the patios will need to have an accessible table. Each of the dining areas will need to have one. So take a look at the table on the left. It clearly allows a wheelchair to slide under, whereas if you see the tables on the right, there are some pedestal style tables. For me, they're not a problem. For most wheelchair users, they're not a problem. But if you have a larger wheelchair, you may not be able to slide your feet under there. And we'll get a little more into that in just a moment. But this, again, is a source of a lot of litigation nowadays, because you have essentially people that just drive up, take a look at the outdoor dining area and decide they want to sue without even stopping and trying out the tables. Typically, this is what you see not only in the United States, but all over the world, is a pedestal tile, a pedestal style table with a round base. And most wheelchairs will not have a problem with this, some will. And so I had a case relative to that. We had Mr. Whitaker, Brian Whitaker, who's filed over 1,000 cases in California, claimed that a restaurant in Beverly Hills had outdoor dining that didn't allow him to dine comfortably. So after much effort, I got a court order to measure up his wheelchair, and we had this graphic made on computer-aided design, and we were able to show the judge that he should have had no difficulty dining at that table. And not only that, but at trial, I had a table and a table setting brought, and a videographer, and the judge was quite happy with the fact that he got to be able to see all that firsthand. Restaurant bars. A person in a wheelchair has, according to the ADA, has the right to enjoy the restaurant bar experience. And so this particular bar is not ideal. because it excludes someone in a wheelchair who might want to sit at the bar and interact with the bartender, for instance, or watch TV and so on. So we had this altered where we lowered a 5-foot section of the bar to allow someone in a wheelchair and his girlfriend or boyfriend to sit there and partake in the bar experience. I think it's a very nice job. It doesn't interfere with the aesthetics of the bar, but it also provides inclusivity, which is obviously what you want. All right, so let's talk about bathrooms and restrooms. For all of you history buffs, you should know that this is an old Roman or Greek outdoor bathroom. And just to throw you off, I added that little accessible sign on the wall. I was going to try to fool you and make you believe that the Romans invented accessible bathrooms. But the fact is, they didn't. Hopefully nobody fell in that large hole back 2,000 years ago. This is something interesting. If you're traveling in Paris, they have these little kiosks called Sanisets, and they're awesome because they provide accessible restrooms for those in wheelchairs. So if any of you have been in Paris, you know that restaurant bathrooms could be extremely small, or it could be down the stairs and up the stairs. And for someone in a wheelchair who needs to dine and then needs to go to the restroom, it's nearly impossible in Paris. So these things are ideal, and as you can see there, you can actually have a map that shows you where these things are. So it's a good thing if you're traveling in Paris. But if you're in the United States, nearly every restaurant today has accessible restrooms, and the design is pretty much standardized nowadays. What you have here is you've got grab bars that have to be placed in the back and on the side. You've got a seat liner that has to be placed within a reach of someone in a wheelchair. You have to have sufficient space, that round circle, for a wheelchair to make a full turn. And you have to have space under the sink to be able to slide your wheelchair under. The mirror has to be low, and the paper towels have to be obviously within reach. So this design is now duplicated in nearly every restaurant, restroom across the United States. Now, hotel bathrooms, a big issue for people like me who are in a wheelchair and who like to travel. This is a European style bathroom. As you can see, the American design of having a grab bar in the back and a grab bar on the side has not been adopted. It's you have a grab bar on the side, which is good enough. The good thing here is you've got a roll-in shower, and if you're in a wheelchair, you can essentially roll yourself in and transfer to the seat, and the shower controls are all within reach. So this is, if I remember correctly, this was a brand new hotel in France at the foot of the Pyrenees in a little town called Pau. I believe it's spelled P-A-U, and I thoroughly appreciated the fact that this was available to me. This is an American hotel restroom. As you can see, it's a lot more In terms of design, it's a lot more rigid. You have to have a lot more grab bars. Again, you have the grab bar in the back of the toilet, on the side. You've got extensive grab bars in the shower, and occasionally hotel management will forget to put a seat in there, and you'll have to make a phone call and have them bring up a seat. But all in all, if you're in a wheelchair in the United States and you're traveling, you are lucky compared, obviously, with traveling the rest of the world. And again, these are issues that come up in litigation, and you deal with it. Strategies. We talked about federal court and state court. ADA cases are brought in California in both forms. Really, you could litigate your ADA case in either form. If you file in the district court, in federal court, it's, believe it or not, it's going to be less expensive for you because the filing fee is going to be $402. And there are no additional fees for motions, particularly for a summary judgment motion. And if you are a frequent filer, if you filed over, I don't know, 100, 200 cases a year, and you want to avoid the additional penalty of $1,000 per case, you can file in federal courts. But federal courts have gotten to be a little smarter about this, and now they, particularly in the Central District, which covers the Los Angeles area, most judges will tell a plaintiff who's filing these lawsuits, look, if you want to litigate in federal court, that's fine. We'll let you litigate the ADA cause of action. But if you want to litigate state claims like the Unruh Civil Rights Act, then we're going to send you back to state court. We're not going to accept jurisdiction as far as the state claims are concerned. So you're finding that most federal judges today will simply allow you to prosecute the ADA cause and dismiss the Unruh cause, but without prejudice. So essentially, the end result is if a plaintiff loses in federal court, or if the case is deemed resolved in federal court, then they file a second lawsuit on the same claim in state court. So it's really not helping anyone. One of the issues that have come up is how specific do you have to be in a complaint? Can you simply say, oh, I went to this business, I poked my head in, I saw they didn't have an appropriate sales and service counter, and I decided to file suit. And this is a case that I defended in the Ninth Circuit and prevailed. It's called Whitaker versus Body Art and Soul Tattoos. In this instance, Brian Whitaker had claimed that he was unable to get a tattoo because the sales and service counter was too high for him, and the Ninth Circuit said no. You've got to explain a lot more as to why you can't get a tattoo just because service counter was too high, and so I'm happy with this decision. I'm gonna rush through here and just give you a sense of what we have to deal with defending small businesses on a day-to-day basis. This particular business got sued and they wanted $12,000 because the website apparently was not available for those with visual impairments. We discovered that the website didn't actually belong to our client, but it was one that was created by Grubhub, and we were able to get the case dismissed. And we felt the demand was outrageous. We got this letter recently from this organization. They claim to be, their name to be, let's see, Pursuit of Respect is the name of their organization. And it's a Florida-based organization. The attorneys are in California. They're suing California businesses. It's essentially a shakedown. And they wanted money from us, and we basically told them to pound sand, and I will put them out of business if they ever pursue this claim. Here's one we just recently got from Scott Johnson, who's filed over 4,000 lawsuits. He had the audacity to claim that he is unable to dine at this outdoor dining area of a very well-known restaurant in San Jose. We just filed our motion to dismiss, and we will not we will not be paying anything on this. The plaintiff had many options as far as dining outdoors. As you can see, he could have easily dined there, and it's a shakedown. Here's another one at a Jersey Mike's in Sacramento. While the table was not ADA compliant at the time, we had that corrected immediately, and we will pay no more than $2,000 for Unruh damages, because we were able to make the corrections within 30 days, and we will not accede to their demands. Here's the sort of claim that I find to be totally frivolous. The plaintiff claims that the slope at the access aisle, instead of being 2% maximum, is 2.4%. For most wheelchairs, you can't honestly tell the difference between a 2 and a 3%. Those are really shallow slopes, and we had a nice conversation with the client's attorneys, with the plaintiff's attorneys, and had the case dismissed. And this is my favorite nowadays. It's taken up quite a bit of my time. If you take a look at the parking lot, you will see that there are some cracks in the asphalt on the right and on the left. The plaintiff here, who walks with a cane, claims that those cracks interfere with his ability to walk, and he wants $32,000 in damages, and he wants those cracks filled in, and he's not going to get anything. I will fight this. I will fight this and take it to trial all the way. This is a frivolous claim, and these claims essentially demean and debase the ADA. This is not what the ADA was meant, was enacted for, not for these frivolous claims. Legitimate claims are fine, and plaintiffs are entitled to injunctive relief where it's appropriate. And I'm going to close with this. This is what happened in Barcelona. I was waiting for a bus with my family, and the bus driver stopped right in front of a tree and pulled out the ramp, and the ramp hit the tree, obviously, and the entire bus stopped and wouldn't move. He couldn't back up, he couldn't retract the ramp, and we had to wait another hour for the next bus, and everybody was angry at me because obviously they knew I was the one that caused this. So we got that resolved. This is my wife and I in Spain, and I was extremely fortunate to be able to rent an electric wheelchair in Barcelona and to be able to use it to get around. It was a lot of fun, and I hope to do a lot more of that in the future. One of the things I was disappointed with is if you're trying to rent a car in Europe without hand controls, almost impossible. So I did not get to drive this wonderful car. My wife did, but next time around, my plan is to take my own car to Europe because I want to experience the freedom of being able to drive. And this was in Bordeaux, France, a wonderful place. It looks like Disneyland, but it's not. I had the pleasure of dining in a restaurant that was established in the 1700s. It had no elevator and no ramps. And before I knew it, two waiters came, grabbed my wheelchair and carried me up the steps and put me in front of a fireplace on the second floor, which I thought was amazing. So it was a good time. Thank you. That's the end of the presentation.
Thank you so much. Why don't you, let's see, go ahead and stop your screen sharing.
Okay.
Let's see. Yeah.
Did
There
I
we
do that right? I don't know. A screen share.
You did.
Oh, I see. Okay.
You did. Your PowerPoint is gone.
All
Well,
right.
thank you so much. That was fascinating. We have a number of questions in the chat. Jeff, did you want to take those, or how did you want to do that?
One question, Jean, is whether Ara will make the PowerPoint be available to answer questions. So Ara, perhaps you want to put your email into the chat, and if people would like a copy of the PowerPoint or have any questions for which we don't have time this morning, they can contact you privately. I'm sure you'll be happy to answer their questions.
So I'm going to put my email here. It's sahelianlaw@me.com. There we go.
Ara, thank you. Ara, let me ask you, what are some typical issues that come up in trying to negotiate settlements of these cases? What are some of the real challenges?
Well, one of the things that plaintiffs' attorneys do, which is not helpful, is they'll make an outrageous demand, particularly if the mediation is at the early on. And their hope is that the case does not settle, so they could essentially generate lots of attorneys' fees and then demand a lot more later on at a second mediation. Unfortunately, that is happening way too often. And what I've found is threatening to alert the magistrate judge in federal court early on to let them know that this sort of gamesmanship is happening is helping. When the plaintiff's attorneys hear that the magistrate judge is likely to get involved, they come to their senses and make a much more reasonable demand. But no one should be paying $9,000 for these cases, which is typically what most attorneys agree to pay. I refuse because it shouldn't cost more than $1,000 or $2,000 to prepare a complaint. If the corrections are made within 30 days, then the Unruh civil rights damages should not exceed $2,000. So the typical value, quick settlement value of these cases should be way under $5,000. No one should have to pay more.
And are there differences between, for example, if you have a mom and pop convenience store, a family-owned grocery store. It was in some of your pictures. How do you distinguish between those kind of cases versus a 40 restaurant chain, which is a completely different kind of business entity?
Here's the sad part relative to some of these law firms that file these cases by the hundreds. They actually press harder on the mom and pop businesses because they know they don't have the ability to defend these cases or to pay for elaborate defense of these cases. So they end up extracting more money out of small businesses than the larger ones that can afford an elaborate defense or even are not intimidated by having these cases go up on appeal. And it's sad. Yeah, there's no distinction made. And unfortunately, judges can't make that distinction. Also, although they can, when it comes to motions for attorney's fees, they will take into consideration that the business cannot afford to be paying outrageous demands.
And finally, Ara, what's the most righteous claim you've ever seen? The one where you looked at and you said, you know, this is what the ADA was intended to resolve.
That happened a couple of years ago, and I told my client that I was going to kick his butt for running a tuxedo store with 9 steps without a ramp for 20 years and getting away with it.
Well, I guess that's a case where the tuxedo store deserved the suit.
Absolutely. I was able to get a reasonable settlement for him, but I would not I would not let him off the hook. I wanted that thing fixed. There's just no reason for it.
Got it. Gene, back to you. We're just about out of time. Thank you, Ara.
Yeah, great. Thank you so much. I mean, the bottom line is you're either in compliance or you're not, for the most part, right, with the ADA. And if as a small business or a business you are not, then you need to become compliant. And then the lawsuit would depend on between the defense and the plaintiff and how you can get it settled or not. But isn't the ultimate goal to fix whatever is not compliant as soon as possible for many reasons? Number one, to comply with the law, but also for your customers, et cetera.
Yeah, but you know, you've got like I said, 270 pages of ADA rules. Yeah. Okay, I had a case where the plaintiff wanted $3,000 because the coat hook in the restroom stall was 3 inches higher than it should have been. So that the client was, you know, left with the decision: do I litigate over a coat hook or do I pay $3,000? Is a coat hook worth $3,000? No. It turns out that the coat hook was properly placed. Unfortunately, there was an incident at the restaurant and some kid poked himself in the eye with it. Okay. And so restaurant management, without thinking, decided to move it up.
Yeah.
You know, so you got a lot of these little things. I can tell you right now, I could go to any restaurant, even across the United States, and I will find something. And if I wanted to sue each and every one of them, I would be able to. I mean, you have to be reasonable.
Got it. Well, thank you so much. And thank you, everybody. Again, the food bank that Ara has asked that we consider anybody who wants to make a donation today is Action Against Hunger. And that's actionagainsthunger.org, serving the global the needs of the global community. So thank you all, and we'll see you next week. Bye-bye.
Thank you.
Thank you,
Thank you, Ara.